Good morning, everyone. Welcome. So glad you all could join us today. So we're here today to talk about the role of extension agents in local food systems, distinguishing government policy and law. And we have Ted Fitzsands with us. Thank you for being with us, Ted. I'll introduce him just in a moment here. So quickly, I wanted to thank our sponsor. This webinar is a part of a larger course that we are running right now that has funding through Southern SARE. It's a professional development program grant, and our collaborators on this include cooperative extension at the land-grant universities and both land-grant universities in Virginia, North Carolina, and South Carolina, so as well as Carolina Farm Stewardship Association and the Center for Environmental Farming Systems. So we thank all of those sponsors and collaborators for their efforts. So Ted Fitzsands, he's an extension professor at North Carolina State University. He received his BS in Animal Science from Cornell, his MS in Agricultural and Applied Economics from the University of Minnesota, and his JD from Georgetown University Law Center. He is admitted to practice in North Carolina and New York. He teaches courses in agricultural law and environmental law in the undergraduate program in the Department of Agricultural and Resource Economics at North Carolina State University, where he serves in both the undergraduate teaching program and the cooperative extension program. Professor Fitzsands has developed an extension education program to provide legal information to a wide variety of audiences on environmental, agricultural, forestry, and related business and legal issues. Professor Fitzsands is currently conducting research on legal issues involving farm business and forest landowner succession, liability avoidance, agricultural biotechnology, waste management, and hydraulic fracturing for gas and oil. He's a member of the NC Bar Association and will assume the chair of the Council of the Environment, Energy, and Natural Resources Law section on July 1st of this year. He has been a frequent presenter at American Agricultural Law Association annual conferences and is a past president of that association. He is the recipient of many awards, including a 2006 AAEA Distinguished Extension Program Award, and that was a team award, and a 2008 NC State Outstanding Teacher designation. He received a 2014 Outstanding Subject Matter Program Award from the North Carolina Association of Cooperative Extension Specialists for his work on hydraulic fracturing. And with that, Ted, I will hand this over to you. We have an hour and a half with Ted, so we're going to try and break this into small chunks and stop and ask questions partway in between. All right? Ted?
Thank you for that introduction, Dara. And welcome to all of the participants this morning. So I'm going to start my first slide with a disclaimer. We all have to have disclaimers in this day and age. That in my role as in cooperative extension, I'm an educator and I do not give private legal advice. That's important for all of us in extension because sometimes you will get questions that shade into giving legal advice, and that's prohibited by state law in all states except Arizona. And that can expose you to liability. So if somebody's a farmer or somebody else that you work with in your role in extension gives you a contract to look at and asks you to comment on it, you can certainly look at it. You can talk about whether or not the contract does what they want it to do, but you can't give them any advice about whether the contract is legally enforceable because that shades into the role of what private attorneys do. And of course, for those of you who are not attorneys, you're not qualified to do that. And in my case, my position prohibits me from doing that because the University and Cooperative Extension don't want the liability exposure. I also have presentations that I do on liability avoidance for extension agents, but I'm not going to go into detail on that today. So let's talk about what government is. And let me say at the outset that this topic is very difficult. I'm currently teaching my online class in environmental law and economic policy, and I invited students in that class to participate, and it looks like some of you are, so welcome. As they are finding out, the topic that we have today is a very difficult topic, and that is made worse by the decision of many, many states and their high schools to no longer teach civics. And that gives students with a high school education a very limited basis for understanding what we're talking about today. And unfortunately, when you go to college, you usually don't get much education in this area in your program in college, and part of that has to do with the fact that there's more and more to learn, and some things get crowded out. So let's start with a basic definition of government. A government is an entity with sovereignty. And for most of you, that probably means nothing at all. And I'm going to try to define sovereignty as we go along, and I'll continue to come back to it as somewhat of a tautology to say, as a definition, that sovereignty is that which a government has. Is a circular argument. But sovereignty is that unique characteristic that defines government. There are two theories of government in the world today. The more prevalent view of government comes from the Enlightenment, and it is based on a concept of consent of the government. This is the basic concept behind most democracies. Examples in the United States and France. The other view of government, the other theory, which is much older than the consent of the governed view, is that governmental power comes from divine authority. And this is part of the concept of sovereignty. So there's some divine authority. Of course, there are always arguments about the character of that divine authority. And some portion of that divine authority is transferred to the monarch or other ruler. And examples of those in modern terms are England and Thailand. There are also many others. And so the governmental authority doesn't come from consent of the governed, but from some divine source. And these are two quite different theories of governance. So let's talk about constitutional government, because that is what we have. Constitutional government is really essential for any government based on the consent of the governed, because it defines the powers and limitations of the government, and these are enumerated in a written constitution. Constitutions are much less important for governments that are based on divine authority. England, for example, does in fact have a constitution, but it is considered an unwritten constitution. Not all of it is unwritten. There are pieces of it, like the Magna Carta, that are written. But overall, they don't have a unified constitution in the way that the U.S. federal government does. And the U.S. Constitution lists the powers of the federal government and certain limitations on the power of the federal government. And in a constitutional approach to the federal government has only those powers enumerated in the Constitution. Now, it's not true of state constitutions. State powers are much broader, and there's some powers implied by common law that are not listed in state constitutions. So, you'll hear people usually complaining about government. Oh, like what the government's doing. Well, the real question is, which government? We do not have one government in the United States. Most of us are under the jurisdiction at any given time of at least two governments, in some cases more. So let's talk about those entities that have their own sovereignty. The U.S. federal government is one, the states are the other, and then we have two other categories that have sovereignty. One are Indian tribes, which is the term that I use because that is the term used in the Constitution. And I recognize that others may use different terms, which is fine, but this is the legally operative term because it's in the Constitution. Lawyers spend a lot of time thinking about words because words are our tools. A farmer has tractors and combines. Lawyers have words. And so words are very important when we talk about law and government. And there are also various U.S. Insular areas that have their own sovereignty. Then we have entities that have derivative sovereignty. Derivative sovereignty means that the sovereignty of those governments is derived from another government's sovereignty. So in the case of the federal government, we have the District of Columbia and territorial governments. And those derive their sovereignty from the federal government. And if any of you have ever lived in the district, you will know that the District of Columbia is entirely dependent on Congress for its authority. Do you recall that the district government's authority can be changed by Congress at any time? That's because the District of Columbia has derivative sovereignty that is derivative of the federal government. And so the federal government has the power to dictate to the district what it can do, and even the power to entirely withdraw its sovereignty and rule it directly through the federal government. States have entities within states. In North Carolina, it's primarily counties and cities, also some drainage districts in the eastern part of the state. In other states, townships are often in a active unit of government. We have townships in North Carolina, but they're simply geographic designations. We also have a lot of other authorities. We have water and sewer authorities. We have bridge and tunnel authorities. We have toll road authorities, and on and on. And all of these are entities whose sovereignty is derivative of the state. And that sovereignty was transferred to those entities either by the state constitution or by statute enacted by the state legislature. I see you were also spent time in D.C., Rochelle. So did I. And it can be rather frustrating that you have to go to Congress to do what seems like basic things. And we see tension in states between counties and cities on the one hand and between the states on the other. And it's rather interesting because a county or a city in those states can actually sue the state government, because once the state sets up a county or a city as a separate legal entity, it has to honor the rights that that entity has as a separate legal person, which is not to say that it couldn't abolish it entirely, at least as a legal matter, probably not as a political and policy matter, which we could talk about policy a bit later. So we have entities with sovereignty, we have entities with derivative sovereignty, and those are our governments. Now, we have some entities out there that look a lot like governments, and they can be sources of law, but they don't have sovereignty. Religious organizations, and the various religious organizations even operate their own court systems. The various Jewish groups do, the Roman Catholic Church does, and the Episcopal Church does, to name a few that I'm aware of. And they resolve primarily religious matters and matters relating to marriage. There are a few religious organizations that actually have sovereignty. The only one that comes to mind is the Roman Catholic Church, and its sovereignty is limited to the very small territory of Vatican City. We have, unfortunately, way too many warlords right now around the world, and they have territory that they govern, but they do not have sovereignty. They're recognized by no one as a government. So although they have power, they can be a source of law. Pirate ships are another example, criminal and terrorist organizations. By the way, pirate ships, according to law, are operated democratically. Homeowners associations, this is one of my favorites. Homeowners associations are private entities created either in the covenants of the properties in the development or through the charter or bylaws of the homeowners association. They have a great deal of power. They're also an important issue, usually an impediment for local and urban agriculture. Communes, which were very popular in the 60s and 70s, look like governments, but they're not. They don't have sovereignty. Corporations. Corporations could definitely be sources of law. They look like governments. To give you an example of probably the most powerful corporation in world history was the British East India Company. Those areas of India that came under British control were initially private colonies of the British East India Company. The British East India Company was chartered by Parliament as a private for-profit corporation to colonize India. It raised its own army, which it used in that effort, and Parliament didn't have a problem with that as long as the army was in India. When the British East India Company proposed to establish a navy, Parliament, fearing the power of a large corporation with a navy, revoked the charter of the British East India Company, which meant that it disappeared, and that's how it lacked sovereignty. So it may be a source of law. It may even have an army that doesn't have sovereignty. And I know that this is confusing, so I hope that you ask a lot of questions. The only dumb questions are the ones that don't get asked, so please ask your questions. Now, the important differences when we are dealing with a non-governmental entity. Let's take homeowners associations, for example. When you're dealing with your local homeowners association, if it's a mandatory homeowners association, and what I mean is that you have to follow its rules. There are also voluntary homeowners associations that have no legal power to enforce their determinations. But if you have a mandatory homeowners association, constitutional rights don't apply. They don't have to give you equal protection. They can treat their favorites well and the people they don't like poorly. And as long as that's not barred by the covenants or the bylaws, you as a homeowner really don't have much recourse. As an aside, homeowners association law is one of the fastest growing areas of law in North Carolina. Now, what these non-governmental entities can do can be and is limited by governments through both statutory law, that's law that's formally enacted, or by common law limits that have been established by judicial decisions. So there's a lot of law limiting these private entities, but constitutional rights only apply to governmental action. They do not apply to private action. So if your employer, for example, wants to look at all your emails, wants to put a webcam in your cubicle, wants you to take a blood test to see if you're consuming controlled substances, it is free to do all of that unless there's a statutory or common law limitation that prevents that. All of these non-governmental entities that we're concerned about today have some way to enforce their rules. And we'll talk more about that later. Okay, let's talk about the relationship between federal and state government. This is quite complicated. We have what's known as a federal system, where the federal government and the states are separate sovereigns. The federal government was in fact created by the states ceding some of their power through the Constitution to create the federal government. And by the way, our current Constitution is the second Constitution of the United States. First was the Articles of Confederation. So the Constitution sets forth the powers of the federal government, and if those powers are not set forth in the Constitution, the federal government doesn't have them. So the federal government is very much a government of limited powers, because you've got to find the power in the Constitution. Remember, at least for the 13 original states, they are much older than the federal government. They've existed a lot longer. So we have a principle of dual sovereigns. How does this become important? Well, I can best illustrate that with an example. And I also see that the first 20 minutes has passed. I'm going to go on with this a little longer because this is a bit longer section. So I raised this case in the discussion that we had in our environmental law class this past week, and that is the case of Medellin versus Dretke. It was decided in 2005, and there's a convention. A convention is simply a multilateral treaty, which the United States has joined. So this treaty is the law of the United States because treaties are laws of the federal government. And the petitioner in this case was a Mexican citizen who was sentenced to death in Texas. Under the Vienna Convention on Consular Relations, the United States agreed that before a national of another country that is a member of the convention can be put on trial for a crime, they would have access to the official from the consulate. Texas denied this access to Mr. Medellin, and he ultimately petitioned the U.S. Supreme Court to hear his case, and he argued that the failure to provide him with constitutional access, and not constitutional access, with consular access, was a defect in his trial, and the verdict should be set aside and he should get a new trial. The U.S. Supreme Court rejected this in a per curiam decision. A per curiam decision is an unsigned decision of the U.S. Supreme Court in which all 9 justices agree. So be very clear, this was a unanimous decision. All of the justices agreed that the Vienna Convention created no rights that an individual could raise in court if they were denied consular access. Because what they said is there are only 2 ways that a treaty applies to the states. One is if the treaty is self-executing. That means there's language in the treaty itself that says it applies to the states. Very unusual to see that in a treaty because other governments that negotiate with the U.S. government don't negotiate for that because they don't really understand the need to do so. Secondly, it would apply to individuals if Congress passed implementing legislation. And in the case of the Vienna Convention, Congress has never passed legislation that would apply to the state. So these two conditions, neither of these conditions being present, the Supreme Court ruled that there was nothing that Mr. Medellin had that he could do about it. So the practical aspect of this is treaties do not necessarily apply to the states unless an additional step has been taken to apply them to the states. And that's because the states have their own sovereignty. Now, if that's not confusing, I don't know what is. The relationship between the federal and state governments is defined by the Supremacy Clause of Article 6 that makes federal law, when the federal government has the power to act, superior to state law. So because of the Supremacy Clause, Congress could say that the Vienna Convention must be observed by the states. Since Congress didn't do that, the states don't have to observe it, because this clause of the Constitution defines the relationship between the federal government and the states. Federal government and the state governments maintain separate and independent judiciaries. Precedents, that is, judicial decisions, do not apply across systems. The only federal decisions that apply to state courts are constitutional decisions of the U.S. Supreme Court. So that's not every Supreme Court case, but where the Supreme Court says, we're interpreting the U.S. Constitution and this is what it says, that applies to state courts. And that's because of the Supremacy Clause, not because it's a precedent applying to the states. Also, for example, double jeopardy doesn't apply across systems. In food safety cases, if you have a food safety violation that's a criminal violation, you can be tried criminally in both state and federal courts, and you can end up serving time in both state and federal prisons. The likelihood of that happening is low, but it does happen. Although I don't know of a food safety case where it's happened yet. Just briefly, Indian tribes are very much like states. They have their own sovereignty, and that's further complicated by the treaty obligations of the federal government. There are lawyers who spend their entire lives doing nothing but Indian law. Okay, we've got to policies, so Dara or Joanna, I'm going to shut off my microphone and we can...
Great, thanks Ted. That's a great introduction into government. So Ted, I'll start with a question. There aren't any in the chat box yet, but hopefully folks will start typing some. And what's the relationship between federal and state governments? And your conversation about the Constitution and how that applies. What are the most important parts of the Constitution that relate to local foods and local agriculture?
That's an excellent question. Probably the most important is the Commerce Clause, because the Commerce Clause entitles the federal government to regulate commerce between the states and with the Indian tribes, and the Supreme Court has interpreted the Commerce Clause very broadly, as we'll talk about when we get to our discussion of the Woodford versus Filburn case. So the federal government can often reach down to the very most local matter and regulate it. And we see that with the Food Safety Modernization Act and the exemption for small farms. And the reason that exemption in FSMA, for those of you who don't know it, that's the acronym for the Food Safety Modernization Act. It's abbreviated FSMA, hence FSMA. So through its commerce power, the federal government can reach down and regulate a small farm that is only trading locally. And that's why a statutory exception was necessary. I'm not going to get into a lot of FSMA issues right now, but one of the issues for the small farm exemption is the Food and Drug Administration, FDA, can withdraw that exemption, and that power to withdraw the exemption is based on the Commerce Clause. And when we get to Wickard versus Bilderberg, we'll see just how broad the commerce power is. Second part of the Constitution that's particularly important for agriculture is the Spending Clause. And the Spending Clause allows the federal government to spend its own money. So, for example, if Congress wants to appropriate money to the U.S. Department of Agriculture to make grants to encourage local agriculture, that is the constitutional authority for doing so. So the commerce power and the spending power, to me, are by far the two most important parts of the U.S. Constitution for local agriculture. And I'll stop there.
Great. Thanks, Ted. Any other questions from the crowd? I suspect more will come as we get into policy and law moving forward and get into some of the conversation in local government. And Ted, I'm going to ask one other question, but you let me know if it's better, your response is better suited later in your presentation. But relative to the entities that lack sovereignty and the conversation about corporations, you did mention food safety, and that seems to be a theme here in the responses on this section. With GAPS and Extension food safety trainers, wondering relationship and issues at hand there related to this topic.
Why don't we hold that one until I get a little farther along, because I have some material on GAPS.
Okay.
But it's a great question, and I do intend to address it. And I'd also like to see some discussion about that.
Sounds great.
Okay. Nope, I've got ahead of myself. Okay, what is policy? Policy are those goals of a government. They can be the goals of a non-governmental entity for that matter. Corporations, after all, have policies. So, in the context of government, policy is defined by elected officials based on the role of the public in providing input. And for those of you who have worked in the federal government, as I have, I worked in the civil service. So when you work in the civil service, you don't make policy, because policy is made either by elected officials or their appointees. Those are the at-will individuals who serve at the pleasure of the president. They're presidential appointees. Those are your policy-making folks. And what the civil service does is implement the policy. So civil services staff. And that applies across all levels of government. So you have the distinction, federal government, state government, and local government. You have the elected officials or their designees. Those are your governor's appointees or president's appointees. And then at the local level, say counties, you have the county commissioners who are your elected officials, and then you have the staff. So it's the elected officials or their immediate appointees who are the policy-making officials. Staff doesn't make policy. Staff implements policy. And I hope we have some questions about that distinction. It's an important one. So let's talk about New Deal farm policy. And I have here a quote from Henry A. Wallace. Henry A. Wallace was Franklin Roosevelt's first Secretary of Agriculture. As an aside, for those of you interested in agricultural history, he was also the founder of Pioneer Hybrid, which is one of our big seed companies that was acquired a few years ago by DuPont. And I'll let you read what he says. He's talking about various policy options. But what I'm going to repeat is what he said there is no one wants a repetition of 1932. This is what has driven agricultural policy since the Depression, and it's part of what has made agriculture so difficult. Because with the policy of solving a legitimate problem, of a very pressing problem, and I'll get to that in my next slide. Let me move forward. So what happened in 1932? Well, first thing you need to know is after World War I, starting in 1920, U.S. agriculture experienced a gradual decline in economic well-being. This accelerated in 1929 with the stock market crash, and in 1932, the bottom fell out of it. And I know that recently we've gone through the Great Recession, as it's now called, and we have had a great deal of hardship. But I will tell you, nothing compared to the Great Depression. I have an uncle who's, as a matter of fact, still with us. He'll be 101 this coming September 1st. He is college educated, and he went essentially for a decade without regular work. I have a next door neighbor who's 97, and I asked him in about 2009 how this compared to the Depression, and he just sort of shook his head, said, not comparable. The height of the Great Depression, we had over 25% of the people that were actually actively looking for work who couldn't find any work. That's not just part-time work. They couldn't find any work. Prices paid to farmers dropped by more than 50%, which would have been okay if the prices they paid for their inputs had dropped by the same amount. But they dropped by only 32%, which is a huge amount of deflation. But you see what happened to farmers in 1932. This triggered a farm foreclosure crisis. And by the way, this is part of personal family history. My grandparents lost their farm to foreclosure, actually bankruptcy, in 1932, and they ended their lives as sharecroppers on the land that they had once owned. So, as you can see, there was a serious problem, and the federal government attempted to develop a policy to address this. Unfortunately, as we shall see, local agriculture was collateral damage to this. So, this is the Agricultural Adjustment Act of 1938, which, by the way, is still law. It is superseded approximately every 5 years on a temporary basis by the Farm Bill, which is why we have Farm Bills on a regular basis, because the 1938 Act and the 1949 Acts are what are known as permanent legislation, and they are superseded by Farm Bills approximately every 5 years, and those Farm Bills are temporary legislation. But this law remains on the books and enforceable in the absence of a Farm Bill. So here it is, and sometimes Congress provides us with a policy statement, and here it is. And the bold is mine, and that part I would like to read to you. To assist in the marketing of agricultural commodities for domestic consumption and for export, and to regulate interstate and foreign commerce in cotton, wheat, corn, and rice to the extent necessary to provide an orderly, adequate, and balanced flow of such commodities in interstate and foreign commerce through storage of reserve supplies, loans, marketing quotas, assisting farmers to obtain insofar as practicable parity prices for such commodities and parity of income, and assisting consumers to obtain an adequate and steady supply of such commodities at fair prices. And it's not in the statement, but parity was deemed to be a relationship between what farmers sell and what farmers buy, as it was in the period of 1910 to 1914, which was a good period for U.S. agriculture. So why is policy important? It does two important things. It informs the laws to be enacted. A law is enacted because we have some policy we want to implement. So in this case, the federal government wanted to stop foreclosures. They wanted to increase farm prices, and so they enacted the Agricultural Adjustment Act of 1938 to do so. As I noted in an earlier slide with a quote from Henry A. Wallace, the Supreme Court held that the first Agricultural Adjustment Act, the Act of 1933, was unconstitutional, and they invalidated it. So the Act of 1938 was a response to that Supreme Court decision. The second way policy is important is once you have laws, it determines enforcement and application of the laws. Any administration has a great deal of latitude as to how laws are going to be enforced and applied. For example, I heard on the radio this morning that the Obama administration intends to raise the threshold for time and a half, more than double it from the mid-20s to the low 50s. So if you're making $51,000, I've forgotten the exact amount, less than that, you will be entitled to time and a half if you work more than 40 hours a week. And the administration can do that without any input from Congress, because Congress has already enacted the law, and the law gives the president the authority to set that threshold. Now, Congress certainly has the power to enact a law to take that power away from the president, but the likelihood of them doing so is fairly low. Because once the president has raised the level of entitlement to time and a half, which is going to affect 5 to 6 million people, it's very hard for Congress to pass a law reducing the money that people are effectively making. That's not politically supportable, even though it's constitutionally and legally possible. Okay, that is the policy section. So, Dara, I'm going to shut off my microphone and let you see if there are any questions.
Thanks, Ted. This is Joanna again. So we did have a question earlier that applied. It came in a little bit late as you started into your policy section, so I wanted to go ahead and ask it here. So what happens if FSMA, the Food Safety Modernization Act, passes but receives no funding to implement it?
That's an excellent question. And let's take that in parts. Let's take the part of the law that requires funding in order to implement. There are certain parts of the law that authorize the Food and Drug Administration to make grants to the states and to, I think there's even grants to producers. I'm sure you probably know the answer to that, Rochelle, and feel free to put something in the dialogue box. But I forget who gets grants under FSMA, but I know they're there. If Congress never funds that, obviously FDA cannot make grants. So that part of the law would not be implemented. However, there are parts of the law that are what we call self-executing. And that means those parts of the law happen without an appropriation and without any further action by Congress. So a good example of that is in the last section of FSMA on the employee protections, and that gives employees of food facilities who believe that an adverse action was taken against them, either they were fired or demoted or something like that, because they reported a food safety violation either to their employer, to a state attorney general, or to any federal official. And that entitles them to file a complaint with the Secretary of Labor. And the Secretary of Labor has issued a very short regulation designating OSHA to take those complaints. But other than that, no regulations have been adopted at this point. We simply have the bare statute. And by the way, if OSHA doesn't act on the complaint, the complainant is entitled to go to federal district court. I already know attorneys that are handling these cases. Those cases are going on now because that part of the law is self-executing. So the question is going to be whether or not appropriations are required to implement a particular part of the law. And if a particular part of the law doesn't require appropriations to be enforceable, then that part of the law is going to be enforced by the courts in the absence of any appropriations. So I will turn it back to you, Joanna.
Thanks, Ted. And Rochelle has posted some information into the chat bar. Thank you, Rochelle. Folks, Rochelle Sparko is with Carolina Farm Stewardship Association. As I mentioned, has been a partner in putting this course and these webinars together. So thanks, Rochelle. She said this is a chronic issue. There are separate committees and separate bills for substantive law versus funding. The Farm Bill, for example, passes approximately every 5 years and comes with recommended funding amounts, but then the Appropriations Committees vote about the funding that will actually be dispersed, and those may be different from the amounts in the substantive bill. Are there other questions? And while we're waiting for those, Ted, would you like to respond to Rochelle's comment?
Yes, I agree with Rochelle's comments, and having worked in Washington, I'm personally familiar with the problem because you've got a set of committees for the substantive law, one in each, at least one in each House of Congress, and then you have the Appropriations Committees in the Senate and the House of Representatives, and they are not the same people on those committees in most cases, and they usually have different priorities. And while the committees that proposed and drafted the substantive legislation that was enacted had one thing as a priority, the representatives and senators on the Appropriations Committees, they have completely different priorities and choose not to fund the part of the statute.
Okay, thank you, Ted. And we have a question from Dara. I'm wondering what the implications are of AAA. Is it in effect if we have the Farm Bill?
Could you, AAA, what is the acronym?
Sorry, I meant the Agricultural Adjustment Act. I was lazy and didn't write it all the way out.
Oh, okay, sure. Yeah, if Congress fails to pass a Farm Bill, then the Agricultural Adjustment Act of 1938 comes back into full effect. And this is what drives the Farm Bill process, because the Agricultural Adjustment Act of 1938 requires that the government support the price of supported commodities, wheat, corn, rice, and so on, at parity for the 1910 to 1914 period. And that would cost the federal government an enormous amount of money. I've forgotten what it was. That came up in the last Farm Bill debate. But it would literally break the bank. So it's the existence of the 38 Act and the 49 Act that really drives Congress to enact farm bills, which is why some people in Congress were proposing to repeal the 38 and 49 Act so they didn't have the necessity of passing another farm bill.
Great, thank you, Ted. So I don't see other questions. Scanning back through to make sure I didn't miss anything. And so, Ted, I'll hand it back to you and let you go through the next section. Thank you.
Thank you. Let's start with law. This is going to be our last section. And there are two conditions for the existence of law. One is a set of rules, and the second condition is that enforcement power exists to enforce those rules. Notice that in this definition of law, you find the word government nowhere. You can have law without government. Law is much older than government, as a matter of fact. Humans did not organize themselves under governments until relatively late in human history, basically at the point in time in which humans formed settled agricultural communities probably about 10,000 years ago. But we had law long before that. I also want to, at this point, say what is meant by the rule of law. Because the rule of law is a concept that is very important. The rule of law is actually an ideal. And the ideal is this. The law will apply to every individual in a society equally without regard to race, sex, national origin, religion, and wealth or poverty. It will be applied equally. Now, we all know that that doesn't happen. But the fact that it can happen, at least to some degree, is important, and the fact that it is an ideal to be strived for provides stability and fairness in the society. One of my favorite attorneys of all time was Thurgood Marshall. Most of you probably know him, if you know him at all, as the first black U.S. Supreme Court justice. But long before he became a Supreme Court justice, he was an attorney for the NAACP, and he often represented black defendants in the segregated South being tried before what was theoretically a jury of their peers, although it was an all-white jury. And sometimes he succeeded in his representations. It was dangerous work that he did. And I mean physically dangerous at that time. And yet he could succeed in his representation because the judges and lawyers in the systems understood that at least theoretically the law applied equally to all people without regard to race. And the rule of law is what has made the progress toward more equality in our society possible. I'm rather passionate about the rule of law, as you can probably tell. And I would also add that it's a fragile ideal. We have to work to maintain it. Okay. So let's look at some non-governmental examples of law. Good agricultural practices, for the purposes of our discussion, are very important. They are implemented by third-party certifiers. While there may be government involvement, some governments may actually be certifiers, so it's a complicated situation. In general, it is a non-governmental type of law because it's a set of rules and there is enforcement. The enforcement is simply that buyers won't buy your products without being GAP certified. Now, you could sell it to somebody else who's going to limit your market. So there's definitely an enforcement mechanism there. Organic standards prior to the enactment of the Organic Foods Production Act of 1990. So before 1990, organic standards were very much like GAPs. They were non-governmental standards, and if you wanted to sell your product as certified organic, you had to meet those standards. Homeowners associations. Have a mandatory homeowners association. Your homeowners association rules say no commercial production of vegetables in your backyard. You decide to raise tomatoes and sell them at the local farmer's market, or worse from the point of view of the homeowners association, you decide to sell them, have your children sell them on a little stand in the front yard. You're going to get a nasty letter from the homeowners association that tells you to stop. If you don't stop, they can go to court. They can get an injunction to prevent you from continuing to do it. If you continue to do it anyway, they can have you cited for contempt of court and jailed. They can also recover from you whatever the costs of bringing the action against you are. And if it's necessary to sell your house to do so, they can force a judicial sale of your house. I would say there are definitely enforcement mechanisms there, and they are definitely private. They are created by the covenants and the deeds for each house in the subdivision. So those are non-governmental examples of law. So we've seen non-governmental examples. Let's talk about where laws created by governments come from. We have in the federal government, we have the legislative power, the power to make laws, which is vested in Congress, subject to a presidential veto. At the state level, that power is vested in state legislatures, subject to a veto by the governor. We have the judicial power. In common law systems, courts are sources of law. When a court decides a case, that written decision becomes a precedent for future cases. And so we've got the federal court system and the courts of the 50 states all deciding cases. All of these courts are constantly creating new law when they get new situations before them or issues involving a statute that have never been addressed before. So we have legislatures, we have courts that are sources of law. And I want to distinguish talk a little bit more about the distinction between common law systems, which basically exist in the English-speaking world. Great Britain, the United States, Canada except for Quebec, U.S. states except for Louisiana. Louisiana uses a civil code system because they're based on French law. Australia, New Zealand, India, all common law jurisdictions. France, Germany, Japan, China are all civil code systems. The features of the common law system, because I said courts create law, is the principle of stare decisis. And under that principle, decided cases become precedents for that court and any court in the same system that is inferior to the court that wrote the opinion. And by inferior court, I mean a court from which a case would be appealed. Now, let's look at a practical example that's going to pull all of this together. Henry A. Wallace said, we don't want a repeat of 1932. So what New Deal farm legislation sought to do to implement the policy of avoiding the problems of 1932 was to limit crop acreage, limit marketing of covered commodities. And I've used the term covered commodities. Let me explain what that means. The law didn't apply to all agricultural products. It only applied to the major commodities that were listed in the statute. And it required the sale of excess to the federal government. Now, for milk and fruits and vegetables, we had marketing orders, and I'm not using that in my example, but I am going to talk about it because the U.S. Supreme Court on June 22nd released an opinion in Horn versus the Department of Agriculture addressing the constitutionality of federal powers under the marketing order system, which is similar to the system for commodities, and they held it unconstitutional. So, but that doesn't apply to the Agricultural Adjustment Act of 1938, although based on this recent Supreme Court decision, I suspect that parts of the 1938 Act are unconstitutional. But maybe not, because this required the sale, whereas under the marketing order system, the product had to be given to the federal government, which is quite a distinction. But I'm getting ahead of myself. So we have the executive power to make laws. So I've already mentioned treaties. The president has the power to make treaties. So when the president signs a treaty, that's a ratification of the treaty. It then has to be, the Senate then has to give its advice and consent. In other words, vote on the treaty for it to become law. The president also has the power to issue executive orders stating how particular statutes will be enforced. This gets back to policy. The president's administration has certain policies. Through executive orders, the president explains how that policy translates into enforcement of particular statutes. And a similar system exists at the state level, except that under the U.S. Constitution, the power to make treaties is a power that states gave up. So treaties cannot enter into binding agreements with foreign governments. Then we have administrative agencies that are a source of law, such as the Farm Service Agency, the USDA Risk Management Agency. So Congress passes these very broad statutes, and there's a lot that needs clarification, so the agencies will then take the statutes and they will fill in the gaps by developing regulations. So the regulations are also a form of law, but they're a form of law that's inferior to the statute. And these are generally done through the Administrative Procedures Act process, requiring that a proposed regulation be published in the Federal Register, it be open for public comments, and then the agency will publish the final regulation as it becomes law in the Federal Register. It either becomes law upon publication or upon some date set in the regulation itself. So let's look at an actual judicial decision. Wickett versus Filburn, and this case is still good law. And by the way, to clarify my terms, when a lawyer uses the term good law, that doesn't mean it's a law that you like or that you think it's good policy. It means that it's a law that is still valid and enforceable. So, Mr. Filburn owned a small farm in Ohio. It was a Hamilton County, Ohio, which is basically Cincinnati. In fact, I suspect that his farm is now part of Cincinnati. He wanted to prevent enforcement of the provisions of the Agricultural Adjustment Act of of 1938 against him because he wanted to raise and sell wheat in excess of his acreage allotment and his marketing quota. So under the 1938 Act, each farmer got a certain amount of acres upon which they could grow a commodity like wheat, and then they were allowed to market a certain quantity of wheat. So there were two prongs in the 38 Act to controlling the amount of commodity going onto the market. One was to restrict the acres through allotments, and the other was to restrict marketing through quotas. And he objected to this. He ignored it. He was fined. He refused to pay the fine. And I'm not going to read all of this, but you can read it. He, as I say, he had a diversified small farm, a herd of dairy cattle, selling milk, raising poultry, selling poultry and eggs, and a small acreage of winter wheat, and some of which he used to feed poultry and livestock on the farm, some of which he sold, some of which he made into flour for his own consumption. And this next slide tells you the enforcement action that was taken against him. I'm not going to go into the details there. You can read it. On the next slide, the court explains how the 38 Act worked. And I don't think it's on this slide. Maybe in the next one. But at the time, this decision was decided in 1942, 20% of all the wheat produced in the United States was being used by the farmer for home consumption. 20% of all the wheat produced in the United States was being used for home consumption. This is real local agriculture. What do you think the percentage is today? I'm sure it's much, much lower. Of course, production's much higher too, but very few people grind their own wheat in this day and age. There are some, I know some, but they're not many. So part of the 38 Act was that there would be a referendum. And the referendum passed overwhelmingly. Only 19% of the farmers were opposed to imposing this scheme of allotments and quotas. So this was democratically approved. Here it is. The 20% of average production was home consumed at the time of this case. Now, what the court's saying in Wickard versus Filburn is, remember the commerce power that regulates interstate commerce. The court said in Wickard versus Filburn is the commerce power reaches activities that are solely interstate. Because if you're going to eliminate this 20% of home consumption, that means they're going to have to buy that on the market, and that's going to increase the price. And that's going to implement our policy of not repeating 1932. So I hope you're seeing how this all fits together, whether you like the policy or not. And we got more rationale for the decision, but I have basically summarized it there. So I hope you can see that while limiting local agriculture wasn't the policy goal was to improve farm incomes, to avoid farm foreclosure. Those policy goals conflicted. Now, I briefly want to mention the June 22nd Supreme Court decision in Horn versus Department of Agriculture. And this involves a marketing order, federal marketing order for raisins. Under the Agricultural Marketing Agreement Act of 1937, which is another New Deal farm law, and it is also good law today. And it required producers of raisins, limited the amount of raisins that raisin producers could sell, and required them to turn over the rest of their production to the federal government. And the Supreme Court has recently ruled this unconstitutional. I'll put that in the box. Horn versus Department of Agriculture. And that just came down this June 22nd. So I'm going to finish up my slides here, and then we can go on to the discussion. So local governments can also be a source of law through ordinances and rules. These are adopted by, ordinances are adopted by either the county commissioners or the city council, where we have health boards and special districts such as water districts. Their boards, and they're usually elected boards, vote on the rules. And health boards are very important for local agriculture as well, particularly for whether or not you're going to be able to sell value-added products. Zoning is one type of local enactment enacted by counties and cities. To understand zoning, you will have listed uses for land in a particular zone. If a use is not listed, it's not allowed. And very often in enacting zoning ordinances, because many of these zoning ordinances are decades old, there is no thinking about allowing local agriculture in an urban area. And so if it's not a listed use, you can't do it. And so I'll give you an example of how this works. Let's say that I've got a house in a subdivision zone for single family, and as an accessory use, I'm allowed to have a garden. I'm not satisfied with the size of my garden, so I buy the vacant lot next to me, and I put my garden on that. I am now violating the zoning because a garden is an accessory use. Without a single family dwelling on that lot, I cannot have a garden on it because the garden cannot be the primary use of the property. And so when we get into zoning, it's a form of local law that has a great deal of impact on whether local agriculture can exist at all, quite frankly. Finding these ordinances and rules can be hard because, they may have them on a government website or they may not. The best way is simply to go into the part of your local government that issues them and ask for the most recent copy, because what's on the web may not be up to date. And you are responsible for obeying the currently enforceable version, even if you don't know that it exists. Little bit on non-governmental sources of law. There are many. Homeowners associations rules can be very difficult to find, and you've got some members of homeowners boards who won't give them to you. You may actually have to go to court to get them. And changing them is much more difficult than changing a county or municipal ordinance, because if they're covenants, they're recorded in the deed, and the only way you can change covenants in a deed is by having every single owner of property in the association agree. There may be some other, you may be able to go to court to get them changed, but probably not. That varies somewhat by state and by what the covenants themselves say. So if the covenants don't allow for local agriculture in the subdivision, it may be almost impossible for it to happen. Now, your state legislature could pass a rule, could pass a law superseding the homeowners association's rule, and they in fact did that with solar panels on the roofs of houses. In North Carolina, that cannot be prohibited by a homeowners association rule. So there's an interaction there between government and non-governmental law, and the the government has the power to modify the non-governmental rules subject to certain constitutional limitations. And Joanna, I am going to stop there and shut off my microphone, and hopefully you've got some.
Great. Thank you, Ted. It's very interesting, and you've put a lot of information into a short period of time here, so thank you for that. I asked in the chat box if folks are hearing from clients with issues related to zoning with community gardens and urban agriculture, and we have one person that's responded, bees are wanted by the public, but local governments prohibit keeping bees in the city. Ted, would you like to respond?
Yes, this is a contentious issue, and probably more contentious than it should be, but nonetheless it is contentious. And the only way to get those rules changed at a local level is to talk to elected officials, demonstrate to them that the bees are not a hazard to the public, develop public support. I think backyard chickens are a good example of where growing public support for them has led to many municipalities changing their rules. So this is getting these rules changed is a slow, time-consuming process, but that's really the primary way to do it. There is one other way to do it, and that is for the state legislature to preempt local rules prohibiting bees, but persuading a state legislature to pass a law is time-consuming as well. So those are the two ways you could change the rules.
So Ted, with the topic of this webinar focused towards extension agents, what role can they play in that conversation?
Oh, that's an excellent question. The extension agents have an important role to play. They can facilitate groups that are interested in local agriculture. They can help explain the issues to them, and that's one of the reasons for a course such as this one. They can identify resources for groups in local agriculture. What an extension agent can't do is lobby their elected officials for particular changes in the rules, and that's because the extension agent is actually a government employee, and so it's generally inappropriate to do that, because as a government employee, you serve the whole public, and by advocating for a particular position, you're going to get in the middle of the fights between people that disagree on policy. What extension agents can do, however, is advise elected officials on and make themselves available as a resource for their elected officials to help their elected officials understand the issue. It's a difficult role for all of those in extension, myself included, because the boundaries are never a bright line. They're always gray areas.
Right. Thanks, Ted. So Rochelle did mention in the chat box there's a bill in the General Assembly this year that would remove local authority to regulate fewer than 5 beehives. It didn't move much this year, but I imagine that it will keep coming up. That's good information, Rochelle. Thank you.
Yeah, thank you. That's and that's an example of exactly what I was talking about. I'll give you
so then we have another.
Oh, go ahead.
Go ahead. Go ahead, Ted.
Last year, or the year before, the General Assembly passed a law that bars municipalities from prohibiting private wells within city limits. And that's very important for local agriculture because you really need a source of water independent of city water for a variety of reasons. It lets the cities regulate those wells, you know, in terms of their location and standards for the well, but a city can no longer prohibit a private well within city limits. So that's another example of state legislation that restricts the city's ability to regulate.
Thanks, Ted. There's another comment in the chat box too. It says we have a township that has ordinances to prohibit the raising of livestock on less than 5 acres of land. However, the ordinance for horses dictates only 1 acre of land. It's convenient there is a thriving horse industry in that community. A large number of families there have children involved in equestrian competitions.
So what is the question there? That's certainly something they can do. And the fact that it's 1 acre for horses and 5 for everything else is most likely enforceable because we're talking about different types of animals. So if that's what the city wants to do, they almost certainly can. I'm not sure. There may be a follow-up question there.
I think it was more of a comment than a question, but I appreciate your thoughts on that. And then we have another here. What are the other major legal pitfalls agents need to be aware of in their efforts to support local food systems development, other than the issue of advocacy for themselves and for their clients? Good question. Thanks.
There are a number of them. One is actually getting involved in an activity, such as helping producers make value-added products for sale, for example, or even for giving them away. And I won't say that that can't be done. Some of that can't be done in extension, but if you're going to do it, you need to discuss it with higher-ups in extension. You need to discuss it with your county government. You need to make sure you have adequate insurance coverage and everybody's covered. So one of the things that I see from time to time is extension agents probably getting too involved in actual production. So that's one issue because that's a source of liability. I mentioned earlier interpreting legal documents, and there's always a temptation when you're handed a document to try to explain what it means. If it's a legally operative document like a contract or a covenant in a homeowners association deed, those are interpretations that you can't do.
Thanks, Ted. And we just have a few seconds left. With the Wickard versus Filburn, that was an interesting case to share. And for those of us without the legal background, it would be great to have just a thumbprint summary. We heard you say that these laws come through with valid reasons to solve problems at that point in time, but are sometimes based on incomplete information or have different consequences in the future than were expected. Can you just give a thumbprint summary of that?
Okay, so Wickard versus Filburn basically said that the commerce power allows Congress to regulate agricultural production to the local level, even to the point of prohibiting production for one's own consumption, where Congress has found that that's necessary to achieve other policy goals. Turn it back to you, Joanna.
Great. Thank you, Ted. And we are out of time here. We have recorded this. We will post it to the website that was in the email that I sent to you. I'll post it here again in the chat bar momentarily. And I'm going to send a survey through to you that should open up in your on your own computer there. If you could give us some feedback, we'd appreciate it. While folks are doing that, we had one last question in the chat box. Ted, what steps would one take if they were trying to change a covenant?
Changing a covenant, as I said, is difficult. But if you can get unanimous agreement, you can change the covenant, and you'd have to have new deed language drafted. Otherwise, I would talk to a local real property attorney and ask them to examine the covenants and see if there's a way to modify them.
Thank you, Ted. Ted, thank you so much for all your time you put into putting this together for us and for being here today. Thank you to everyone who participated and for your great questions and thoughts you contributed. And we look forward to providing some more webinars in the future. We'll just need your input on the topics. Thank you.
Thank you.